Hello, and welcome again. In the last section, we talked a little bit um, about the structure and scale and about some possible explanations for the violence that occurred accompanying the breakup of Yugoslavia in the 1990s. In this section, I want to talk about what happened after the period of violence ended, because the period of crisis does not end with the end of periods of violence. In this instance, after a series of wars that were fought around issues that revolved around disputes over the independence of territories, what we saw was that conflict between the groups and representatives of groups involved in violence deepened, and a new, often large, set of grievances tended to emerge. So states emerged from a period of violence and from a period of authoritarian control with damaged reputations and in a condition where there was distinct unreadiness for states and societies to reconcile with one another. There was also uncertainty in the period following the violence regarding the readiness of states to integrate with international institutions, and in particular peacekeeping institutions and institutions related to justice. The international response to this situation took two forms. One form was the imposition of conditionality on states emerging from the period of conflict and violence, and the other was the creation of a judicial institution meant to establish records of violence and to try and punish perpetrators involved in the violence. So let's talk first about conditionality. Now on the slide here, I've given you a definition of conditionality, and this is a definition that is not from the literature. It's derived from a review of the experiences of conditionality. But basically what conditionality meant is that what the states in the post-conflict period were seeking, that is recognition, assistance, progress and integration with international institutions, would be conditioned on evidence that states are cooperating with international efforts to establish justice. To establish justice how? First, by bringing perpetrators to justice. Second, by investigating, by documenting, and by recognizing crimes that have been committed. And third, and this is a vague term, it's a term that has never been defined to anybody's satisfaction, but it appears frequently in the discussion in the post-conflict period, efforts to confront the past. Now, when you look at conditionality as it's defined this way, it seems like there are a lot of abstract goals that are hard to define. And what government and intergovernmental institutions do when they're confronted with the problem of trying to assess the achievement of abstract goals is they turn them into concrete goals. So what happened with conditionality in practice on the ground is that it was reduced to formal and measurable factors, and in particular two concrete factors. It is that the states of the region were expected to provide people who were indicted with crimes to be tried by an international tribunal, and they were expected to provide documents at the request of prosecutors for the investigation and preparation of cases at the tribunal. So what this means is that there was less of a focus on investigation, on documentation, on dialogue, hardly any emphasis on confronting the past, whatever that may mean, and a good deal of emphasis on this first element, cooperating with international efforts to bring perpetrators to justice. One of the things that this meant is that the policy of conditionality achieved some of its intended effects. I think that cannot be denied, but it also had some unintended consequences, and I would define those unintended consequences as falling mostly into two categories. First, formalization. So what we've just talked about, abstract goals get turned into concrete goals. And what this means is that the ways in which these goals are achieved or carried out happens through exchanges and communication involving international agencies on one side and agencies of the states that are subject to conditionality on the other side. Okay, so this is all communication between interstate agencies and governments. And what this means is that the public is excluded from the process, that there is an absence of dialogue. The mechanisms by which there can be some kind of confrontation with the past are not a part of the policy. The second set of consequences we could describe as falling under the category of trivialization. That is, substantive engagement with issues related to justice is diminished, and in fact there's an incentive for politicians to avoid substantive engagement, to say that it is too risky, and in any case there are already international institutions. There is the tribunal established by the United Nations, there is the United Nations Security Council that's dealing with it, so we don't have to. And what this means in particular, because terms like confrontation with the past have never been defined, what happens is there is the postulation of a process with no end. And whenever there is a process with no end, what happens on the political level is that it turns into a waiting game. One side waits for the other side to run out of patience with the process, at which point the side that has not run out of patience wins. And this was a process in which probably the advocates of denial, the final stage of genocide, demonstrated more endurance than the advocates of justice, so that the trivialization that accompanied conditionality often meant that goals were not achieved. But having said that, let's talk about the other element of international post-conflict responses, and that was the formation of an International Criminal Tribunal, ICTY, or the International Criminal Tribunal for the former Yugoslavia, which was in operation between the time it was founded in 1994 and the time in which it closed down in 2015. It filed its last indictments in 2007. So this was an international tribunal, the first international tribunal to be formed by the United Nations. The second international tribunal that was formed was the International Criminal Tribunal for Rwanda. There have been a number of other tribunals formed since, some of them under the auspices of the United Nations and some of them not under the auspices of the United Nations. These were in fact the first international criminal tribunals to be formed in history. People like to refer to the tribunals that operated at the end of the Second World War, the Tokyo Tribunal and the Nuremberg Tribunal, but these were not international legal institutions. These were military tribunals that were created by the victorious parties in the war. They did not provide and did not aim to provide the same quality of fairness of trial that an established legal institution tries to provide. Now, what did ICTY do during the period in which it operated? It filed indictments against 161 people, people who was believed were guilty of committing major crimes of large-scale violence. Of those 161 people, 90 were sentenced, 19 were acquitted. There were 37 cases in which indictments were withdrawn or proceedings were terminated, most of these because of the death of the person who was indicted. There were 13 cases that were referred to domestic courts in the states over which the tribunal had oversight to be tried there. And there are 2 cases that as of today, are still ongoing before the so-called residual mechanism for international tribunals. And those are the cases of Ratko Mladic and Radovan Karadzic, the military commander and political chief, respectively, of Republika Srpska, the Serb entity in Bosnia and Herzegovina. These people are both charged with crimes against humanity, with other crimes, and with genocide for the large-scale killings that took place in Srebrenica. Now, one of the goals of the International Criminal Tribunal was to try people who were accused of crimes and to decide whether they were guilty or not guilty. Another was to produce a documentary record of crimes, and the tribunal produced an enormous documentary record. The transcripts of all of the trials and evidence submitted in the trials is publicly available. It exists at the website of the International Criminal Tribunal, and it altogether adds up to about 2.5 million pages, making this set of crimes some of the most thoroughly documented large-scale crimes that have been committed in history. Can we say whether the International Criminal Tribunal for the former Yugoslavia was successful or not? Well, there will always be criticisms of any institution. It will succeed at some things and fail at others. Possibly the biggest success of the tribunal is that it provided for the first time an example of an international legal institution that could try cases of this type, and its founding was followed 7 years later by the founding of a permanent international court to try crimes of the sort that were committed during the period of violence in the 1990s. So there is now an international criminal court, which again is an object of some contention, but it is a permanent legal institution that has this purpose. So perhaps we could say that the biggest success of the tribunal is the fact that anything was done at all, that any records were created, any trials were held, any people were punished or found not guilty. If you want to talk about the biggest failure of the tribunal, it's probably that. It filed indictments against 161 people. This is certainly much smaller than the number of people who are likely to have committed large-scale and serious crimes during the course of the violence of the 1990s. That is, any legal effort is going to be limited. This one is very limited, and this is a source of ongoing problems for people in the states in the region. Another failure perhaps is that it had great difficulty in communicating its purpose or the meaning of the verdicts that it handed down to members of the public in the states over which it had oversight. And as a result, the effect on public perceptions of the violence was relatively small, at least for now. That is to say that the exclusivist positions that people tended to take that justified the violence at the time when it was occurring continues to be, in many states in the region, the dominant perception in public opinion. In particular, the idea that the group of which a person is a member is innocent and all other groups are guilty. If you want to talk concretely about things that the tribunal did legally, we can say that there are some important precedents. First of all, together with the Rwanda Tribunal, it was this set of tribunals that provided the first ever verdicts on the question of genocide to be handed down by an international court. So the standards for conviction of genocide have been established, and those standards are controversial. There are people who say that they're too restrictive. There are people who say that they're not restrictive enough. But there is something to talk about in the field of law on the question of genocide. A second thing that the record of the tribunal leaves is records establishing gender-based violence and sexual violence as constitutive elements of basic crimes of war and crimes against humanity. And this is a very major step from the previous condition in which these kinds of crimes were very frequently viewed as kind of side effects of war and conflict as not a central concern. So it took gender-based violence, it took sexual violence, and afforded it the importance that that many people argued for a long time that it really deserved. Another thing that we can say is that the record of the tribunal remains a matter of dispute, and this is partly because there are people who believe that that accused people who were convicted by the tribunal should not have been convicted. That is, that these convictions represent some kind of political bias against the groups of which these people are members, and also because of some very controversial acquittals that were handed down by the tribunal. And what most of these acquittals involved is either very narrow application of laws regarding the conduct of armed forces, very narrow applications of principles of responsibility, in particular responsibility of political and military commanders, and some disputed characterizations of what the nature of the conflict was, and in particular whether it was an international conflict or not. That is to say that The acquittals that are controversial both on the level of interpretation of law, but also for a lot of other people as interpretations of history. And it's raised the questions of whether courts are really a good place for the writing of history. Do you really want lawyers and judges doing the kind of work of interpretation that should probably be done on a broader base than legal formulations? Now, in the period toward the end of the operation of the tribunal and following the closing of the tribunal, there has been an effort to move the process of achieving criminal justice from the international arena to the domestic arena, to domestic courts, so that in every state in the region there are now special courts or special prosecutors or both, dealing with crimes committed in the context of the wars of succession. Again, here we can talk about partial successes and partial failures, and as with the case of the tribunal, what the partial successes and partial failures mostly serve as is illustrations of the limited character of political will and political ambition in the states. Now, that's what I'll say so far about international responses. In the next section, what I want to do is to try to provide some kind of assessment of international responses and to talk about some of the initiatives that have followed upon the assessments that were made of international responses in the region.